delegation of the European Union to the United States. Following a similar format that we did previously, we'll start things off with like a slightly longer intervention before we move to moderated discussion. I was hoping to pass it to Sarah first to offer her thoughts on the challenges of platform responsibility and support responsible, ethical, good behavior among online platforms.
Yeah, I've got the solution to that right here. Great, thank you for having me, Michael, and thanks to everyone who's here today and to my colleagues, my esteemed colleagues on the panel. I'm not a lawyer, so but some of my best friends are, so I'll start out by saying that. So my intervention will not be necessarily at the level of legal prescription, but I think I want to make some broader comments today to kind of set the stage for how we got to where we are today. I have been studying content moderation of social media for about 14 years, and when I began the process of studying that phenomenon, it was at a time when the firms themselves were denying that they did any such intervention whatsoever. And the reason was complex. The reason for denying it was complex. There were a couple of issues that I think are important to raise, however, because they are the kind of ideological underpinnings that lead us to some of the outcomes and some of the deep problems that we have today with regard to how these entities engage with the rest of the world. So one of the issues that they had was simply that they were undertaking this practice of content moderation, not necessarily due to a desire to protect either the freedom of expression of users or their well-being, but in fact, it was a mechanism by which they practiced their brand management, and they also practiced their relationship management with their primary customers, who are, of course, advertisers. This was not a clear relationship in 2009, 2010 necessarily, if for no other reason than the practice was hidden, so it couldn't really be apprehended. But what has happened since that time is that content moderation has become one of the main by which platforms make decisions about what ultimately ends up on a platform and what is rescinded. It becomes very hard, of course, to ascertain what is not there. So how do you account for the absence of content, in other words, which is a problematic framing anyway. So this idea of content being something that we sort of all adopted, but is really an industry favoring kind of term, because really what we've done is collectively entered into an agreement that all of human self-expression can be described thus, as content. And what happens is there's sort of a flattening of meaning. This goes to the internal logic of the platforms, where the user-generated content that we're talking about is actually its currency, and it is what keeps users engaged. It's what brings users to the platform in terms of the affordances of the platform. What can they do on the platform in terms of self-expression? And then it keeps them engaged, whether it's creating new material or looking at material that others have created. So what happens is, for the platforms, there is a logic that content is content is content to a certain extent. And actually what they prefer to do is to solicit all of that material and really sort it out on the other end. So that was a business decision that they made early on, to kind of hoover up all of the material that they could to engage users. And then they realized that they had a grave problem in the sense of not having enough control over their own branded sites. And you know, this was at the nascent stage of Facebook itself, and other platforms had really yet to come on the scene, or were just in the process of being born at this time as well. So they came up with this scheme of content moderation, which I can tell you back in 2010, no one knew what I was talking about when I would raise that issue. And I would get two responses to it when I would explain what the process was. Number one was, There's no way that the platforms would intervene like that. They're about giving me freedom of speech. I go on the platform, yeah, thank you, David. I go on the platform to express myself. It's me to the platform to the world, right? Like they would never do that. Their whole raison d'etre is to give me this, this bully pulpit essentially. So I even had people tell me that I was lying about that because that was so against the principles that they had come to understand that the platforms were about. The second response that I would get was, don't computers do that? Don't computers do that? Why do you need human beings to make these decisions? Well, I can tell you in 2010, computers could not do that. They could not do it reliably. Of course, we are in a different paradigm technologically in 2023, and there's a great deal of computer intervention, computational intervention that goes on with regard to content moderation, but I'm here to tell you that it is a human sensitivity and sensibility issue, and no one in the industry who's close to these processes reasonably believes that there is even an upside necessarily to turning this over to computation fully. So the question then becomes, why were those myths so prevalent? And it's not because people are stupid, not at all. I think that the firms did a great job, particularly in the United States, appealing to the norms and the values that so many of us hold dear, things like the ability to express ourselves without, largely unfettered, let's say. But they elided many complex issues, such as the fact that a constitutional right to freedom of speech has very little to do with your ability to do anything inside a private corporatized space. They did that deliberately because, of course, that was the draw to bring people in. And then they kept their practices to really control the content quiet because, quite simply, they did not see it as advantageous to have to be responsible for the decisions they were making to the general public. If nothing else, as you can imagine, that kind of need to be responsible would slow things down to such a pace that they felt that they couldn't and wouldn't be able to keep up with the need to cull content, which again was all about making a hospitable environment for their primary business customers, that business-to-business relationship with advertising. So that is kind of the background on how these practices came to be. Now, since that time, there have been many, many other kinds of practices that have gotten bundled into content moderation. And we often think of it as people outside the firms as first and foremost a mechanism by which users are protected from harm on a platform. I believe that those things are very much commingled at this point, but if you think about content moderation as being primarily a brand management scheme, you come to understand that, in fact, the first goal with content moderation, and I give this story because I think we can extrapolate it out to many of the other decisions that get made by these firms in other areas of kind of control within them. The first and primary decision making that they which is themselves. So at a point, if it becomes disadvantageous for them to, say, protect particular groups of people who find themselves in harm's way disproportionately, they are likely to not continue to do that, with the only kind of significant pressure, at least in the United States context, being that of public opinion. That has a lot of favor, that does make them react in a lot of ways and has done so over time with regard to content moderation practices, which they are now somewhat open about because we all know about it and we all know that it takes place, but that was really a process in and of itself. And so in 2023, we get to a place where we have sort of these opposing forces. We have this notion still, I think, and by we I mean in the culture, in the zeitgeist, we have a sense that something about social media and other kinds of internet-based platforms are in the business of providing expression, self-expression, and free expression to people around the world. And I think what has really happened is that kind of notion has gotten bundled up with the platform's desire to have its own freedom of expression. But that's a very different kind of freedom of expression. And in most cases, it looks like freedom from expression. I'm not so sure anymore in 2023 that we can presume I don't know that we ever could, but I certainly don't think that today we can presume that Google's desire to have unfettered business practices that are unimpeded by regulatory apparatus is the same type of freedom of expression that individual people think about around the globe when they want to get online. And they have done a great job of that kind of coupling up, such that many civil society groups, NGOs, have often found themselves in strange allegiances with these firms over the years, largely in opposition to what has been a specter, at least in the United States context, of government overreach in the space. Internationally, of course, this is the case too. But I think this might be for us to collectively start to reckon with what the implications of those relationships have been. I'm not so sure, for example, that we can certainly know that government regulation is inherently going to impinge freedom of expression in a way that is suggested by the firms. I think they're much more concerned about their own well-being, and they have found a convenient way to find people to rally around that same notion, although it is a very different standard for those two constituencies. The last thing I'll say is that we have a really great, unfortunately, case in point of how these principles start to diverge when the rubber meets the road, and that is, of course, the case of Twitter and its purchase by Elon Musk, and essentially the unraveling of so many of the protections and policies that were put into place over time by people who often came out of public policy roles, and they came out of international relations roles, and people who took their work very seriously and often engaged with people in government and civil society all over the world. When Elon took over the company, it became very clear that that social contract that so many of us imagined we had with a platform like Twitter really was unidirectional, and it was us imagining it onto the platform. But the platform really didn't have that same kind of notion in mind. Essentially, what I'm suggesting is that under the paradigm of for-profit, particularly publicly traded firms, but not even, because we know that Twitter is now private and doesn't trade on the stock market, there is always going to be a tension between some of these principles and the underlying profit motive that the firms have. And I'm here to tell you that internally in these firms, when it comes down to one or the other, the decision will be made on the side of profit. In companies that are it's even on a quarterly cycle. Now, things like protecting human rights, protecting freedom of expression, working on election integrity, et cetera, those don't really work on quarterly cycles. And so it becomes very difficult to show a financial incentive for firms to continue to invest in those areas. And so someone like Elon Musk comes in who has very little commitment to those issues and really doesn't know anything about the space, and those are the first things to get the axe. I spent a bit of time at Twitter last spring. I was asked to come and work there to work on issues of content moderation to improve the experience that the content moderation workers within Twitter had. When they invited me to do that, I said, "Are you sure you've got the right person?" Because I am fairly critical of these companies and their treatment of these workers. They said they did, and they brought me in, and within a matter of weeks, the Elon situation started. And I knew for a fact that any work that I was going to do to try to improve the well-being of the most exploited, perhaps, workers inside of tech companies was going to be tossed out. And indeed, that is what happened. So I guess I'll leave it there with those remarks about trying to set the context for where we are in 2023, and I'm sure that my colleagues on the panel will speak to some of the legislative efforts and regulatory efforts that are underway. David and I just returned from UNESCO a few days ago, where there's an effort underway to build some international multi-stakeholder coalition around a proposed language and regulation, but I'm sure you're going to have some thoughts. So thank you very much.
Thanks, Joanna. I think that's an excellent framing of the problem, and the challenges in grappling with platform power sort of lead us very neatly to the question of regulatory and legislative responses. They will go to Joanna first to discuss the legislative landscape in the EU, and then I'll answer some of them.
Hi everyone. So, thank you so much for having me here. My name is Joanna Smolinska. I'm the deputy head of the newly established European Union office in San Francisco. We are a very small office. There is a big EU delegation in Washington, D.C. We are a pilot. We are the first country where the EU has established a second outpost. And I think the reason we're here is, and our background, so my background is, I come from the European Commission and I work in DG Connect, which is the department where DSA and DMA were born, drafted, impact assessed, and consulted. And my boss, who is the head of the graph, he was the director of the directorate where these two laws, and also platforms to regulate platforms business, were developed. So the era of the internet optimism is definitely over, as Sarah very eloquently presented it. But I feel almost overprivileged to come and speak about what the EU is doing about these problems, because we are lucky enough to have a European Commission that has a legislative initiative in the EU. The EU, which is a group of 27 countries that can come up with laws, has a mandate. The EU has a mandate to propose and enact and implement laws that that cover, let's say, cross-border issues. So the EU doesn't have a mandate to regulate on everything. The EU doesn't regulate on everything, but the EU regulates a lot on digital, because digital, as we know, is borderless. Internet is borderless. Big tech is acts in a global way. So we haven't started from zero when we started working on DSA. The digital sphere has been regulated in the EU since 2000. Some of you may know about the e-commerce directive, and the liability regime for the platforms that has been established then, so 23 years ago, has remained intact in DSA. That's the interesting side of it, because the way the Commission and then the EU, all the United States and the European Parliament really agreed on liability of platforms is to keep it separate from the responsibility that they have for content moderation, where the illegal content is tackled on this is Digital Services Act. Does not define what is illegal and what is legal. It defines the mechanisms that platforms have to establish to moderate content, not for profit, but taking into account freedom of expression, taking into account media pluralism and media freedom. This is explicitly put in the text of DSA. And other fundamental freedoms of the users. So it's not a content moderation Wild West style. It's content moderation fundamental rights style. Another, I can delve a little bit more into details maybe later on to leave some time to other panelists. Another landmark legislation passed at the same time as the Digital Services Act is Digital Markets Act. I don't know if some of you have been, some of you have been here at the first panel where we spoke about how to tackle whether all the issues should be tackled in one legislative instrument in one go, or whether the economic dependencies, whether the uneven platforms power, the kind of unheard of bargaining power that they have over the business users should be tackled in one or a different instrument from the one that we tackle content moderation. Well, the answer is we tackled it in two different legal instruments in the EU, and the second one that tackles the competition side is the digital market, where the platforms who will be defined as gatekeepers, those who provide for so-called core platform services like marketplaces, social media, cloud, search engines as well. They will have to comply with a number of do's and don'ts, with a number of very straightforward, very clear blacklist of prohibitions, and additional list of obligations and requirements that can be discussed with the regulator in regulatory dialogues. Turning a little bit more specifically to the topic of the seminar, the symposium, about the DSA and DMA are not the only legislative bills that tackle freedom of media and sustainability of journalism. The EU has also reformed the copyright regime in 2019 because the copyright regime was not adapted to the digital era. It was not adapted to changing business models in the digital market. And the copyright reform enacted in 2019 that entered into force in 2021 has one specific article on publishers' rights. It's a specific neighboring right introduced in the copyright regime of the EU to bring more protection to the media sector, especially to press media. And you have now been negotiated the European Media Freedom Act, where the place of media plurality, independence from the government's influence is very prominent. I think I just like to turn into.
So the EU is one of the regulatory big players in this space. Another one is the state of California, where a lot of these platforms, or most of these platforms, are based, and which has the power to set regulatory trends, both here across the US and internationally. To Jesse to discuss the ambit of regulation here and the interaction between state action and platform responsibility.
Yeah, absolutely. Good afternoon, everybody. Thank you so much for having me, Michael. It's an honor to be here. I'm glad to see that my constituents are doing such important work. I have the great privilege of representing about 500,000 people from Van Nuys to Woodland Hills in the San Fernando Valley. If any of you here in the city want to come, I can stamp your passport if you want to come to the Valley. That's actually one of my official responsibilities. But maybe more importantly for this conversation, I also chair the Assembly Committee on Privacy and Consumer Protection. So this is a relatively new committee in the California State Legislature, but we are sort of the hub for regulations that involve the internet, technology, and social media companies. And assumed that chairmanship just about a year and a half ago, so relatively new to the space. I'll just say a couple of things, maybe about some of the work that I've done and that we've done, but also sort of how we got here and how we think about this, or at least how I think about it as chair of the committee. So one of the things that I always tell people is I feel that here in California we have both a special opportunity and a special obligation to lead on some of these issues. So special opportunity in the sense the EU, as you've heard, is very active on this. Some might say that our government in Washington is not quite as functional, and there's an inability there to do some basic things, and often an inability there to do some really hard and difficult things, particularly when there may be a partisan divide on them. So we have a very different opportunity here in the legislature. We have a Democratic supermajority. We're a much more active legislature. I take about 6,000 votes in a 2-year session. We're doing a lot of work on a lot of different issues. And if you can get, if you can get some consensus inside the legislature, it's very likely that you can change the law in the state of California, not only for the 40 million people that live here, but often pass laws that will become, have impact beyond our borders, as I think was alluded to, but also become models for work that they're doing in legislatures in other parts of the country. Also feel a special obligation to do some work in this area. A lot of these companies technology companies are homegrown California companies. We're obviously very, very proud of our innovation ecosystem here in the state of California. Very, very proud of all of the creative people here who are doing work to change the planet. But we do feel a special obligation to regulate these companies because they are based here in the state of California, and because they are having impacts far beyond their borders. Some challenges that we face, different sitting in the legislature than it is in Congress. So first of all, the First Amendment, which applies to Congress as well. So that is a big issue that we have to consider as we regulate. I'm a big First Amendment guy. I believe very deeply in freedom of expression. So that's something that we have to navigate. The other thing that's unique to state legislatures is federal preemption in areas where Congress has preempted us, prohibited us from acting. Obviously, Section 230 is the most obvious example of that. So we had been thinking for some time about, I had at least, about content moderation. I'll tell you the way that I arrived at this is, as we were looking at the panoply of challenges in front of us in the legislature, so many of the things that we were looking at ultimately led back to social media in one way or another. So I was elected not that long prior to the COVID-19 pandemic. And a lot of the conversations that we were having at that time were with the California Department of Public Health, things around vaccine update, COVID misinformation, and all of these challenges that we were having because of disinformation about public health issues on the internet, most of it coming from social media. So that led us to it. We're talking about this unfortunate rise in hate crimes and hate-motivated violence that we've had in the state of California. That, in a lot of ways, led back to social media and content moderation. We're talking about all of the challenges with children's mental health and all the links between that and the internet and social media. And then obviously these, everything that happened in January 6th and the threats to our democracy and the way that misinformation and disinformation are threatening to tear apart our democracy and a lot of our civic institutions. And so all of these different public policy challenges that we're looking at in some ways led back to this issue of social media and content moderation. And we were really sitting there trying to think about, what can we do? What are some constructive things that we might be able to do in this space? The idea that we ultimately settled on was a bill that I introduced, Assembly Bill 587, which focused on transparency as a way to deal with this issue. Understanding that things beyond that might be difficult either from a constitutional perspective or from a Section 230 perspective. And what that legislation that was signed into law after a very, very complicated multi-session fight, so I was able to move that bill through the Assembly the first year that I introduced it, but it got bottled up in the state Senate, in the Judiciary Committee there. There was fierce opposition from a lot of these major platforms, not without resources, not without influence in the Capitol, the best attorneys, the best lobbyists, a lot of folks coming to the table and making good arguments. We were ultimately able to break that bill free and get it signed into law last year by Governor Newsom, and it will go into effect in the beginning of 2024. The idea and the thesis behind that bill is that the platforms need to be transparent about what their moderation policies are. So we're not telling them you have to have a particular content moderation policy, you have to moderate particular types of content. We're not making those decisions for you. But we are saying that you have to be transparent with the public and with policymakers and with academics and researchers and others in the space about what your policies are. We call out a number of specific things: disinformation, hate speech, racism, extremism, foreign political interference. Tell us what your policies are, tell us how you enforce them, and then give us a little bit of the receipts. Give us a little bit of the data that will allow some of the smart folks up here and others of you in the audience to really understand what these platforms are doing, with the idea being here that the thesis also is that they are sensitive to public opinion, right? And if they're going out there and saying, we have a robust content moderation policy, and anyone who puts up content that is inciting violence against people because of their sexual orientation or their gender or their race, we take down immediately, well, then show us the receipts. Show us what your moderation policy is and how you deal with that. And again, I think part of the challenge here is we understand from Frances Haugen, from whistleblowers in the space, and also just from the general way in which these companies have operated, they often have misaligned incentives. Their incentives financially are oftentimes to let this content proliferate. It can be very, very engaging content. Things that are racist, that are hateful, that may spark outrage or ethnic violence in certain places. That's the kind of content that can get you a lot of eyeballs. And when your business model is based on user engagement, or your business model is based on monetizing people's attention, sometimes amplifying this racist content is actually really good for the bottom line. Or amplifying this disinformation is really good for the bottom line. Has really corrosive effects on democracy. Has really corrosive effects on a lot of things that I think a lot of us care a lot about. But there is a fundamental misalignment there And we hope that this transparency about forcing them to be a little more public about what they're doing is going to give them some of the right incentives to do the right thing. So that's the big picture on what we're doing. Number of other bills on related issues, but I want to be sensitive to time. And this is our approach that we've taken here in the state of California.
Thanks. The focus on process is really interesting, particularly as it seems to be a commonality between these two approaches as perhaps an area that's less fraught for government intervention than where to draw the line between acceptable and unacceptable content online. David, in your prior role as the UN Special Rapporteur, as well as in your current role, you've had a broader vision of the evolution of this regulatory space and challenges in promoting responsible conduct. Would love to hear your thoughts on how it has evolved and how it continues to evolve.
Great, thank you, Michael. Thanks to everyone for being here. It's really an amazing panel. And you know, so first, I just want to say two things about the panel. One is you might not realize because she doesn't tout it, but Sarah Roberts basically invented the field of commercial content moderation. So sitting next to you, Sarah, is really always an honor. And I also just want to underscore the fact that we have a basically a European ambassador to Silicon Valley. And right, so you're I don't know, do we call it like Technomax or senior envoy? So, but I just wanted to underscore that because I think it's really remarkable and it shows not only how this issue of platform regulation, but really platform power is such a dominant theme worldwide, but it also shows, I think, how Europe and others see that power as almost like a state-like power. They're not, I mean, Facebook is not a state, but they have that power of real sort of dominance over so much of our public space, and particularly in Europe, that I think that's notable. So I just wanted to, excuse me, say a few things. I'll say 4 things, although the 4th thing will be like 10 things, so I'm cheating, basically. So the first is, I think the moment really is, like we're in the midst of a reckoning. There's no question about it, that we have a reckoning that is leading to regulation. I mean, some of us have been saying for many, many years, regulation is coming, so this is sort of an example of if you say something long enough, eventually it will happen, like your predictions come true. So that is happening, and I think part of it is really rooted in deep alienation that is rooted in power, right? So in Europe, for example, you know, there is real alienation, I think, from companies exerting massive power and limited interaction between people in Europe, for instance, or really many other places, and those places of power. Just to give you one example, Europe developed these institutions called internet referral units over time. These IRUs sort of popped up in many countries, including in Europol. And these were units where basically there'd be cops you know, scouring the internet, scouring social media to determine, like, where's the hate speech, where's the illegal content, where's the extremism, however you define extremism. And you know, IRUs would tell me, I mean, the people of these IRUs would tell me, like, they don't know who to call at the companies. Like, how do they do that? But their colleagues in, say, US police forces or security services in the US, they had a line to, you know, to the companies. Why don't we have one? So there is a disconnect, a very big disconnect, and that's just Europe. It's also, you know, clearly a global issue, and you see it not just in democratic societies. You see it in places that, I mean, used to be democratic, but have moved away from it, like Turkey, where, you know, you have real pressure on the platform. So part of this is about a reckoning. Okay, so the reckoning has led to, I think, some very rich thinking about what it means to regulate the platforms. I mean, both on the academic side, but also, you know, in legislative and regulatory space, there's just a ton of really interesting conversations taking place. And I will just like very much simplify the different models, because there's, I mean, a range of models out there for regulation. And I think there's sort of 2 kinds of models. So one is and I'll use Europe with a footnote, because I'll still say UK is Europe. There's two sorts of models. One is the EU model, which just in terms of the DSA, I think it's a model that actually is very similar to Jesse's, to AB 587, to 587, which is a model of transparency and risk assessment as tools that actually introduce to the public what's actually happening under the hood. And clearly the theory behind that is if you publicize it, you'll have sort of a conversation with the platforms that is more rooted in reality, let's say, rather than the companies are a little bit like the national security state, trust us, we're here to protect you. And transparency aims to undermine that. I mean, in 2018, when I did a report on content moderation for the UN, the thing I don't know if this will ever happen, but it was sort of my dream, was like you have sort of develop kind of a radically transparent case law for what the companies are doing around content moderation. There's not going to be real case law. And when we talk about the companies as if they're courts and stuff, that pushes a little far, but we do need to have that kind of insight. So that's one model. And that's a model that I think, as Joanna described, is not a model designed for government to really get in and say, do this, do that with respect to specific content. Although we should be realistic about what Europe has done. It has a terrorist regulation, has a copyright directive that really does, and it has different hate speech laws that actually do get more into telling the companies what the content moderation should look like outside of the DSA. And that's something that I think in a First Amendment context would not be plausible, although Texas and Florida might differ there. The other model, and that other model is more content specific. That's what the UK's online harms bill, which seems to die and arise from the dead every 6 months, sort of with the UK governments. But that approach, which is also sort of a NetzDG approach, which was the German law several years ago, that in some ways kicked off the European focus here. Those approaches are much more attuned to the actual content and government playing a role in moderating, sort of taking over the content moderation in some respects. I mean, UK legislators wouldn't say it that way, but their duty of care, which is really an innovation, which I wouldn't knock totally, but that does move the companies more towards, or moves government more towards getting involved in real content. Okay, so those are two models. I think a third point that I would just say there is that there are some, I hate the word, but they're holistic approaches, and the European approach really is that more holistic approach. It's not just DSA, but it's DMA, which is kind of competition oriented. It's the AI Act, it's the Media Freedom Act, which I want to get to in a second as well. So there are other approaches, and I mean, we should just pause as Americans and really wonder why our approach is such a clown car when it comes down to it. I mean, really, if you think about the approach, I mean, there's some really smart people doing some really interesting things, but nothing like what's happening in Sacramento, as Jesse described. So, or certainly as to what's happening in Brussels. So what's missing? So I just want to run through just a few things about what's missing, or even some issues to think about. One thing that's missing, I think, is civil society, right? So none of these approaches really give, I mean, there are things like trusted flaggers and other approaches, but none of them are genuinely alive to the way the internet, or at least internet governance, developed, which was very multi-stakeholder, which means it involved civil society, it involved technologists, it involved academics. It's possible that the transparency approaches will be a wedge to allow that to happen, but we don't see that in the lawmaking, and we don't see that, for example, Sarah mentioned the UNESCO meeting. We don't see it in their draft guidelines in any particular way. So that's one thing. There should be a more assertive role for civil society. A second thing is, and this maybe ties to the press freedom part of this conference, we don't see a lot of, I call them from a human rights perspective, positive obligations. Like we don't see, like a lot of this discussion, again, with the exception of the Media Freedom Act, we don't see a lot of discussion that actually brings together two important things. One is what's happening on the online platforms, and then the other is what's happening to journalism. So I see Julia Engwin is here, right? We must be thinking about what's happening to journalism all the time. I mean, we also need to have a theory of how to ensure that in digital space we have a diversity of voices, right? And that's actually, that diversity of voices is something that has been problematic from the start with the centralization of social media. So I think we need to be thinking a little bit more about that. We need to put more into the center of these debates. Again, Europe does this better than we do. Consumer protection, so thinking more about business model as part of this. And then finally, we also have to have realistic conversations about trade-offs. And by that I mean, there's obviously a lot of, like my dad would say, there's a lot of dreck online these days, right? There's a lot of, how do you define dreck without, anyway, there's a lot of stuff out there that we want to counter, right? There's hate speech, there's all the things that Jesse was mentioning, for example. And there's something that we want to do about that, and we really should be pushing the platforms to regulate those things. But we should also be alive to the fact that there are trade-offs. This is just true of any policymaking. There are trade-offs to anything we might do or might urge government to do. So for example, the harder we push the platforms to take down content quickly, the more we push them to algorithmic, essentially upload filters, which will be a kind of prior constraint on speech. And so we need to think that through. How do we push the platforms in a way that doesn't do that? The copyright directive in Europe, I don't think really strikes the right balance on that. Although there could be difference of views, and I think it's a rich area to explore empirically, but that's one of the problems. The terrorist directive in Europe also really pushes in that direction. And then two last things. One is we also have to include in this issues of privacy and issues like anonymity. Anonymity has been a great engine for speech and politics in many, many places around the world. And as we push hard, we also want to make sure that we protect those things. And then the last thing, and this was just something that struck me in sort of the California context. So California has a sort of special responsibility, I suppose. But does that responsibility, and does the responsibility for, that California thinks it has, or that Washington thinks it has, or that Europe thinks it has, is it only for those jurisdictions? Because a lot of the worst stuff happening online is not happening in California. I mean, bad stuff is happening, but it's not happening in California, in Europe, or across the United States. As bad as stuff is, it's really bad in those places where the platforms are very distant from the people who are affected. And when we talk about that responsibility, does that extend to extraterritorial legislation so that content moderation, transparency, and all those rules also apply to what Facebook is doing in Ethiopia, or not doing in Ethiopia, or in Bangladesh, or you name the country where you might have concerns about ethnic divisions or other kinds of problems? What is the reach of our law? So I'll stop there.
I was really glad that you mentioned trade-offs and the example of IRUs, as well as Texas and Florida, because I think it takes us to questions about the appropriate limits or challenges of government intervention in this space. And I'd be interested to go to Jesse first, if possible, because I'd be interested to hear how you approach that, particularly, obviously here in the US there are constitutional rules which apply to some states and apparently not others. But I'd be interested to see, your view on the appropriate role of the regulatory space and where it starts.
I think it's a great question, maybe the question about some of the work we're trying to do. And I'm a recovering attorney, is how I describe it. I don't really. Hi, thank you. I'm Jesse, I'm a recovering attorney. Nice to see you all. And look, we have some of these, some of these limits I talked about. Although I will say with this new Supreme Court, I'm quite unsure of what the Constitution says anymore. I'm, old enough to remember when reproductive freedom was a fundamental right. But there are real challenges here, and I think we all have to be honest about the challenges here. And some of these decisions of content moderation are incredibly difficult, right? And one person's hate speech is another person's truth, and there are just such challenges here with all of this. And you brought up Texas and Florida. I like the idea of government getting involved here because the current situation from my perspective is unacceptable and causing a lot of harms in all of these ways that I described. The idea of Ron DeSantis regulating the internet and telling you doing content moderation policy makes me extremely uncomfortable from where I sit, right? And so we were very careful actually in crafting our law in California to try to distinguish ourselves from the approach of Texas and Florida. It's a very different approach with a very different thesis behind it. But there are real limits, and we have to acknowledge that. And it is particularly difficult in a society that is as divided as ours, where people are very, very skeptical about this. I was at an event recently, Berkeley, UC Berkeley, my alma mater, is doing a big cross.
Go Bears.
Go Bears.
Sorry.
Go Bears. I'm a Bruin by affiliation. My father's a professor here, but Bear by heart. They're doing a big cross-segmental university collaboration on this issue. And Irvine Chemerinsky, the dean of the law school, was talking about, the thesis of conservatives is that conservatives are being silenced online, and that's the motivation for some of their laws. And our theory is that there's not enough moderation, and you have all of these harms, and that the liberals are coming from a very progressives are coming from a very different place of wanting this. So there's frustration from all corners at the platforms, but often motivated by very, very different theories. And you do get into incredibly difficult and complicated and sticky questions of having government moderate content. I mean, that is a really, really complicated thing, and that is part of the reason why we feel like we're on safer space with this approach we've taken, as you noted, that is more about process than it is about specific content.
I don't know, Joanna, did you?
Thank you. So I'll get to the question in about 1 minute, because I'd like to let Jesse know that we're actually including in our the EU reports about the law and about other California law, because as we think that what happens in California today might happen in the US tomorrow. And we feel very close to what California is doing in that space. We have taken the, not a very pretty word, holistic approach in the EU, as you said, and we're happy with that. So I'd like to also, by addressing that question, we have worked on DSA and DMA for much longer than 2 years that people think that consulting on. Basically, the reflection has been going on for 20 years, but the political push has come recently, and the political push obviously has come recently also based on what has been happening also in the US and what happened on the 6th of January. So I think the main thing that I would like to mention that many people, whilst this DSA was being developed, were pushing for changing the liability regime, for basically kicking out the liability shield that was in the e-commerce directive. The moment the platforms don't take out expeditiously the content, illegal content, the liability is on. The approach we have taken is that platforms are responsible, the biggest platforms, so those who have more than 5 million users monthly, which is 10% of the EU population, they have special responsibilities. So this is also not a regulation that covers the smallest players in the same way as the biggest players. It's an asymmetric one. Those biggest players, they have many more and much more egregious obligations on them than the smallest one, than the smaller one. And whether they are liable or not, they are responsible. They're always responsible, and they are under due diligence. Now, there are many elements in DSA application which will be obviously implemented only in the EU, because EU only has jurisdiction in the EU, but it will become a resource for the world, because the transparency reporting that we have imposed in the EU, and we have imposed in California, will bring a lot of data that will be much more granular than it is now, that will be available to civil society, to researchers and constituencies alike. And we went further than that. There is a provision in the DSA that researchers, vetted researchers, will be able to invoke platform's data to contribute to the risk, to the assessment of their risk assessment. So to the assessment of what they deem they have done, oppression, to gender violence, to media pluralism. ESA introduces that multi-level governance that you're pleading for. And also audits, part of the audits will be public. So there's going to be a lot of data, whilst obviously the law will be applied in the EU. Sorry, the data will be, there will be a lot of data that people will be able to access. I wanted to touch quickly on the extra jurisdiction point as well. When you were in at the UNESCO conference, you guys must have discussed the DFI, the Declaration for the Future of the Internet, where so what the EU is trying to do is the EU and the US have come up with this initiative, the Declaration for the Future of the Internet, where now there are 60 countries that are members of it. And so as obviously there is no extra jurisdiction of the EU laws, but what we're trying to do with the US, together with the US, is to bring those countries in to make them, to kind of convince them that not to come on our side, because many of them are sitting on the fence. We know who our enemies are, but we want to have as many friends as possible that would adopt, regulation or not, but approach to internet that is open and safe and that takes the values that we have built on into the DSA.
Yeah, I'm really glad that you mentioned. I just want to briefly put stop on what you mentioned about the direct access provisions of the DSA, because I find that fascinating as someone who's not an EU researcher, but who is a California researcher. And I think that that's a really interesting way to combat. We talked a lot in our first session about capture. There is a parallel challenge that takes place among researchers who are dependent on platform data. There's a parallel kind of capture that can take place there. I think legally mandating that is a really interesting way to combat that. David, did you want to?
Yeah, I just wanted to add, these are all great points, but I just wanted to inject a little bit of caution, and maybe 2 points of caution. One thing we don't know yet about implementation, we know almost nothing about implementation of the DSA yet, but one interesting thing to watch will be how do these process-oriented pushes, right? They're, sort of how are you doing content moderation? How are you doing risk assessment? When do those kind of bleed over into actual content discussions between officials and the platforms? In a way, it's hard for me to imagine these conversations sort of strictly sticking to, did you provide the right grievance mechanism when we're talking about something like disinformation that interfered with an election. So I think that'll be interesting to watch. And related to that, so that's a little bit of a cautionary thought that I have just about the DSA. And the other is, as much as we want platform transparency, we also have to build in government transparency, because governments are going to be making increasing demand. I mean, they're already making increasing demands on the platforms. And those demands, we might feel, okay, in democratic societies, there's some rule of law around it and great. But as we push for the platforms to do things, particularly outside of the shadow of the law, let's say, that's going to happen without our seeing it. And because ultimately government is what has coercive power over our lives and over our spaces, I think we're going to want to make sure that all of these rules, all of this new law is also subject to the same kind of transparency mechanisms.
Yeah.
I just want to.
Joanna has invoked her right of reply for the DSA.
Just one sentence. Unless I misunderstood you, David. The DSA is not about governments deciding about what content to remove or not and discuss this with platforms. It is about checks and balances with the mechanisms against systemic risks are introduced in the policies. Who decides about illegality of content are the courts, and that stays.
Right. No, I understand that, but it also creates a momentum for new conversations about process and systemic risk. But what we don't know, I think, is just how those conversations sort of move over into conversations about specific kinds or categories of content. I'm not saying that the DSA itself is, we just have to be realistic that law and institutions that we develop do take on a kind of life of their own. And just watching how that develops is something that we'll want to be mindful of. I personally think the DSA is a real positive innovation, but it's just something we need to be watching.
Sarah?
Sure. So turning back to a comment, David, that you made earlier that I think is actually not incidental but central. I do believe that the platforms are operating as if they're nation states, and I think we have to actually acknowledge that. If you need any evidence, I'm here to tell you that Facebook established its own judiciary, so that's all you need to know. They also engage with representatives of the EU as if peers. We're hearing, I hear you on this point about worrying about government pressure, especially in totalitarian regimes and other places that, such as the United States lately, that don't really hold tenets of democracy first and foremost. But I think one of the things that is particular about the United States is not actually an adversarial relationship between government and industry, but actually the case of them being bedfellows to a dangerous extent. And so when we talk about why no legislation in the United States, you need to look no further than the fact that the largest number of lobbyists in DC are represented by Facebook and Amazon, okay? The federal government is captured, to use your term, by these corporate interests. And I really, while of our representatives and senators are probably dumb, I don't think they're all idiots. I think they're actually quite shrewd, and they have made decisions, pro-business, let's say, decisions, or in another way, anti-consumer or public safety. So I want to just make that point that I think we are at a place where there is an unhealthy relationship between the US government, the American federal government, and the platforms, to the extent that while we sit here and we're debating the finer points of some of these legislative and regulatory mechanisms going into place or bills being proposed or whatever, the firms are over on the other side in bed with Congress and working out very undemocratic trade agreements, other governments, to embed within those trade agreements language that is just like Section 230. For example, in the trade with Japan and the Google about this, we've talked about this before, the Google member who was testifying in front of Congress let that one drop, and I almost fell out of my seat. So wherever you fall in Section 230, there's finally a public discussion about it, and just as that is becoming something that is even being debated, wherever you sit on that subject, industry is working with government to enshrine it in ways that we can't even imagine and that we can't really access through democratic means. And so I just want to point that out, that stuff is going on too.
I just want to maybe add a little nuance there, Professor Roberts, from my perspective as an elected official. I don't think anyone would dispute that these companies have incredible lobbying operations and influence and are making, it's all public, you can go see the campaign contributions that they're making and all the other things, the ways that they're exerting influence. I do think that the tide has shifted, and particularly in the last couple of years. A lot of the work that we have done in California has been bipartisan. You've seen bipartisan calls for action in Washington, D.C. on this. I think some of the reason you haven't had federal action is in part because of just the general dysfunction of Washington, D.C. And there is such a strong shift in public sentiment on this that it is now, I know a lot of my colleagues that are afraid to be associated with tech companies, afraid to have anything like this. We have the case of a very nasty primary for the state legislature up in Northern California in a district that included part of Silicon Valley, and the primary attack, hundreds of thousands of dollars of independent expenditures on one of the candidates, was that they had worked at Facebook, and that they were, and the candidate was defeated. very, otherwise very qualified candidates. This was two Democrats fighting each other. And one of those candidates was too cozy with Facebook and too cozy with the tech industry. According to and I talked to the people who were involved in all this because they're part of Sacramento, the single best public polling attack that they could make on that candidate was that they were somehow in the pocket of Mark Zuckerberg, somehow in the pocket of Facebook. So I think there is more interest in regulating these companies, and they have less power in government than they did maybe a few years ago. I think the challenges are there is disagreement between different partisans about how to go about that and what they're trying to accomplish. So I'm not disagreeing with the overall point, but I think it's a lot more nuanced maybe than some might expect.
I have a whole bunch of other questions, but we also have an incredible group in the room, and I want to make sure that there's ample time for back and forth. So if folks have questions, please raise your hand and introduce yourself. Sure.
Hi.